Stand on that side. That's the prosecutor's side. Okay, clause number 326-948, clause number 327-118. Both cases are styled as State of Texas versus Dwayne Joseph Brown. Mr. Brown is, I think he has a case currently in the criminal district court, and Mr. Brown is also incarcerated. Mr. Doyle, you wanted to approach the bench on those cases?
Yes, sir. He's, their courtroom doors are locked. The room to get back in the back is locked, and the phone is not being answered at the moment. So I can't ascertain what's going to happen, but
Okay, but normally, when they have a misdemeanor and a felony case, I see his felony case is set today.
well, that's what I don't understand. According to the information I have, the trial would be next week. This would be the
Well,
announcement for the trial.
I don't, well, we have a, we have a memo from our county health director. We can't have trials for the next 2 to 3 weeks.
I believe that to be true.
Right, so, we'll set this case on the same date with the felony case, if that's fits your approval.
Yeah, that's fine.
Okay, yeah, he's incarcerated, so, we can't get him here anyway, because they only appear on Zoom. So
Okay.
he's on Zoom in another court, okay?
Yes, sir. And I'll try to find out some more.
Okay, thanks. Okay, we're on the record in cause number 323227, State of Texas versus Samuel Hayden Falk. Mr. Falk, would you come forward? Who's the process? Mr. Boyd, is this your case or is this Ms. Maxis? Ms. Maxis, okay. This is cause number 323227. Case of style of State of Texas versus Samuel Hayden Falk. Is that your full name?
Yes, sir.
How you doing, Mr. Falk?
Pretty good.
That's
I'm
good.
retired.
Oh, okay. Yeah, we need to get our rest. Now, Mr. Falk, you represented here by your attorney, Mr. Bruce Smith. Mr. Smith, how are you doing?
Fine, Your Honor, how are you?
I'm doing fine. Now, Mr. Smith, I see Mr. Falk's case is on our pretrial plea docket. You have an announcement you'd like to make?
Yes, Your Honor, this case, we announced it last time that we needed a trial.
Okay, we're gonna give you a trial date. Our court coordinator will give you a trial date. Just hold on a minute. And in the meantime, we need, I looked here, I noticed he didn't have any bond conditions. He has a DWI second, is that correct? That's what it says here on the docket, sheet, the DWI second. Information
Well,
reads the
Your
DWI
Honor,
second.
The allegations do contain alleging a prior back in June of 2008.
Yeah, okay, I'm looking at the information. He's charged with a DWI second. Let me give you, you can hand this to your client, standard bond conditions. I'll go over that with him. Mr. Falk,
Yes, sir.
document that you've just been handed is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that?
Yes, sir.
I will go over these conditions with you. Following arrest and or accusation in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body. And that's pursuant to the Texas Code of Criminal Procedure, Article 17.44, Section 2 and section C2. Do you understand that condition?
Yes, sir.
Now, condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense. The defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
And condition number 4, a defendant who has been, now this condition applies to individuals who have a DWI second or more, or second, third or more, okay? And it says a defendant who has been arrested or accused of any subsequent offense listed under section 49.04 through 49.06 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before the 10th day. Actually, it was supposed to be after arrest, but it's gonna be on or before the 10th day after today. Okay,
If I may, Your Honor, Judge Woods, he's implemented these before, so I know to follow all this.
This case got transferred out of Judge Wood's court to you.
so, okay,
It's been a
oh,
while.
so I was wondering why, okay, so that's why we didn't have the bond conditions, because
Right.
that's my first time seeing it.
It was our understanding he was already under these bond conditions.
Right, he already has a interlock?
Yeah, and we have a home unit. Because
Okay,
I'm not driving a vehicle right now.
well, it says that any vehicle that you own or operate has to have a,
I don't operate a vehicle.
okay,
His mother drives him everywhere.
okay,
Judge,
all right. Yes,
I have a question regarding it. There's a motion regarding the defendant's competency that was filed back in March. Was there a resolution made in CC3 regarding this, or what's the status
here,
of that?
you said something, the defendant is competent, and that was signed, that was a note, I'm looking at Judge Wood's notes, that's on the file, hold on.
We had him examined by Dr. Capon, and Dr. Capon found him competent.
Yeah, I have a.
Okay, I just didn't have whatever the updated, whatever the resolution was in my file, so I needed to note that. Thank you.
Yeah, let's see. Yeah, he's, yeah, Dr. Capon's report, that was dated May 17th of 2021, finds that he is competent.
Okay, thank you, Judge.
Thank you.
Okay, so we need to, get your case, reset for trial, is that correct?
That's correct.
Mr. Smith, just, get your reset from our court coordinator. You can go back to office and get your reset. And Mr. Falk, we advise that you just make sure that you follow the conditions of this bond. If you fail to follow any one of these conditions, your bond can't be revoked. If your bond is revoked, that means you could be put in jail. All right,
Thank
just
you.
have a seat. And Mr. Falk, once you get your reset from your attorney, you'll be free to go. You have a blessed day.
Thank you very much, sir.
Okay, you're welcome.
And he said,